Judy Wilson, Red Hummingbird. I'm from the unceded territory of Secwepemc Ulu, which is BC region. Welcome to the webinar, Comparing Funding Models for the Loving Justice, the National Reform for Children and Family Programs and Services. I just wanted to start off with a prayer and an opening. Cook's Jam, Kilcook, Great Spirit, we thank you for today. We thank you for the countless blessings, Creator, that we are seen, unseen, and unheard, that are around us every day, from our ancestors to our guardian spirits to all those that walk, crawl, and swim, Creator, that are also part of the plants and the trees and the all that we see and all that we hear. So we thank you for that, Creator. The reminders of from creation that we're energy and we're all connected. Everything is connected, and what we do to Mother Earth is what happens to us. So it's reciprocal relationship we have. So thank you for the spring reminder. The spring equinox is coming up, that we can do that in a good way through prayers and ceremony. But we also want to remember the celestial, our star relations with the planetary alignment that happened this week, and then also the lunar moon eclipses as well. So we thank you for all of those reminders, how we're connected, and to take care of, as caretakers, all that we walk on, and Mother Earth and the creation, but also take care of ourselves and take care of each other in a good way. So thank you for all those that joined us in our circle to share the knowledge and wisdom and expertise they have regarding children and families who are at the center of the circle always, and we keep them in our hearts and we keep them in our thoughts, and we pray, Creator, most of all, we keep them in our actions, so that our actions will speak loud, and to be able to ensure that our children have a good quality of life and the racism and discrimination will end for them, because it's so paramount and prevalent today. Many children are still on the waiting list for Jordan's Principle to get the services that they require, but also that the programs and services do not provide them what they need on a timely basis. And we pray that that's change that we're praying for, so that they can live their full potential and they can have the safety and have a home and have everything that a child ought to have. So we pray for that, for them, their families, and their communities. So we thank you, Creator, for all that you provide for us each and every day. And we pray that those that need the love, support, and resources, the ones that are struggling mental health addictions, and the elderly, and the ones that are infirmed, we pray that they'll get what they need in a good way as well, Creator. So please thank you for the ancestors, the knowledge holders, and all those that carry the bundles for us across the country. Cook's Jam, Cook's Jam, Cook's Jam, Cook's Jam. Thank you, Chief Bowden, and all those on the call. Thank you.
Thank you. Thank you so much for that, Judy. It's always wonderful to have us open up with a prayer. I would like to welcome our panelists and our participants, and thank you to the Our Children, Our Way Society for hosting this webinar. My name is Erica Bowden, and I am the Chief of Cowsas First Nation from Treaty 4, and I am also Saskatchewan's regional representative for the National Children's Chiefs Committee. So we have a lot of information to share today, and I look forward to sharing this all with you, and look forward to sharing this information. And once again, thank you, Judy, for the prayer. So let's look at a little at the plan for let's have a look at the plan for our webinar today. I will provide a little bit of background just to remind everyone how we got to this point and why we have these two long-term reform plans, the Loving Justice Plan and Canada's Plan. After that, our first panelist will be Stephanie Wellman from the First Nations Child and Family Caring Society. Stephanie will give us an overview of the funding approaches in the Loving Justice and in Canada's plan. Then we have Richard Gray, a member of the National Children's Chiefs Commission technical team. Richard will cover the key considerations and comparisons between the two plans where funding is concerned. And finally, we'll hear from everyone's hero, our own Dr. Cindy Blackstock, Executive Director of the Caring Society. Dr. Cindy will share some key questions to consider when reviewing these funding models. After those three presentations, we will take your questions. We have extended the webinar session for this week, and we will have some extra time to answer your questions. I know there are always a lot of questions regarding funding. Before we dive into the material, I have just a few housekeeping points. This session is being recorded and will be available on the Our Children, Our Way website. We have French interpreters available on a separate channel for the Francophone participants. Just a reminder to our panelists, the interpreters are working hard to keep up, so please remember to slow down. We will save time for questions at the end. Please type your questions in the chat, and I will read them out for our panelists. Finally, we will be hosting one more webinar 2 weeks from now. This one will focus on service level agreements, which are the funding agreements between Canada and the provinces and territories for First Nations Child and Family Services. Next slide, please. To provide a bit of context, let's talk about the human rights complaint and how we ended up with 2 long-term reform plans. Canada launched the First Nations Child and Family Services program in the early 1900s. From the beginning, it was very clear that the funding for that program was deeply problematic. For years, our First Nations experts and leaders tried to work with Canada. They provided solid evidence and good solutions, but Canada did very little to fix a program that was harming so many of our families and children. In 2007, the Caring Society and the AFN filed a Canadian human rights complaint against Canada. And finally, in 2016, the Canadian Human Rights Tribunal found that Canada was discriminating against our children in the First Nations Child and Family Services Program and Jordan's Principle. The tribunal found that the funding was discriminatory and that Canada discriminated in the design, management, and control of the First Nations Child and Family Services Program. The tribunal ordered Canada to stop discriminating and to make sure that the discrimination never happens again. And the tribunal decided they would supervise the process of ending discrimination and would do that in 3 phases: immediate measures, medium-term reform, and long-term reform. There were many immediate and medium-term measures, including funding at actuals, and that's very important, at actuals and prevention funding at $2,500 per person. Now we are in the long-term reform phase. The goal now is to fully, that means completely, end Canada's discrimination in the First Nations Child and Family Services Program and to make sure Canada does not discriminate again. You will recall the draft agreement from 2024. This was one attempt to come to an agreement with Canada about how to truly end the discrimination. As chiefs, we decided that agreement was not strong enough to protect our children and future generations. We rejected that agreement and created the National Children's Chiefs Commission to negotiate a stronger agreement. But Canada, it was Canada that refused to negotiate. In August of last year, the tribunal ran out of patience and ordered the parties to come back in 4 months with a long-term reform plan. The tribunal encouraged Canada to work with the National Children's Chiefs Commission and come back with a plan that everyone agreed to. But Canada refused. Instead, the Caring Society worked with the National Children's Chiefs Commission to consult with First Nations and experts and write the Loving Justice Plan. And Canada wrote their own plan based on the final agreement that we have already rejected. So here we are now with 2 plans to consider. The tribunal will consider these two plans and make a final ruling. As chiefs, we also have to decide if we support the Loving Justice Plan, and it is our duty to fully understand these two plans before making that decision. I will turn now to Stephanie to introduce herself and give us an overview of the funding approaches in the two plans. Welcome, Stephanie.
Thank you so much, Chief Bowden, and thank you, Judy, for the opening prayer. And hello, everyone. My name is Stephanie Wellman. I am a Red River Métis from Manitoba. I'm currently joining you guys from unceded, unsurrendered Algonquin territory in Ottawa at the Caring Society office. And I'm joined with my friend Spirit Bear just over my shoulder. And just want to acknowledge everyone that's joined us today. And for me and Spirit Bear, just sending well wishes and hope everyone's doing well and staying warm. I know it's quite chilly everywhere. So what I'm going to be covering is a bit of a background and context setting for this webinar on funding. As you guys can imagine, funding covers everything. So we tried to be really targeted with our conversation today. So to start, just a disclosure that we always provide, and it's just that the Caring Society is a co-complainant in this case, and also that nothing in this webinar is legal advice. We always encourage everyone to talk to their experts and their own legal counsel for any advice. And as well, as my friends are popping in the chat, there is resources and information that's on the NCCC website as well as fnwitness.ca. So we'll also be popping in some resources as they come up. So next slide, please. So we always like to share a reminder about what this case is all about. And, there is, this case is about permanently ending the federal government's discrimination against children, youth and families in Child and Family Services and Jordan's Principle. And as Chief Bowden reviewed, this case has a very long history and it's been ongoing for quite some time. And some of the more recent things that are really important for you guys to be thinking about and be aware of is how we got to this point. So as a quick reminder, because all these things build onto each other. So in December of 2021, there was the agreement in principle that the CHRT parties signed. So that was AFN, Caring Society, Chiefs of Ontario, Anishinaabe Nation, and Canada. So the agreement in principle, or the AIP as we call it, was really the roadmap to get to a final agreement. The AIP is not legally binding, and it was meant to be, again, a roadmap to get to ending Canada's discrimination. And we understood this as a framework with flexibility to improve as evidence and discussions with First Nations evolved. So following the AIP that was signed in December 31st, 2021, so just before 2022, in December of 2023, the Caring Society filed a Jordan's Principle non-compliance motion with the tribunal. And this is still ongoing, more updates to come on that. But because Caring Society filed this non-compliance motion, we did have to leave negotiations. So following this, in July of 2024, that's when the draft final settlement agreement was negotiated with AFN, Chiefs of Ontario, and Anishinaabe Nation. So like Chief Bowden went over, First Nations did not approve this draft final settlement agreement because leadership decided that it didn't meet the needs of children and family to ensure that discrimination doesn't happen again. And we'll be touching on this throughout the webinar, but as a reminder for why the FSA was rejected was because it had many shortfalls. And oh, I hope you guys are hearing me okay. So some of the concerns was that the funding was time limited and dependent on government political decision makers. Um, there was increased funding for inflation and population growth, but not if systemic issues arose. Um, there was opportunity for regional variations, but not if it would cost Canada more money. There was a lack of evidence for how some of the approaches were created within the rejected draft FSA. And a big concern for leadership was the governance. First Nations essentially didn't have a decision-making role after the FSA was approved, if it was to be approved. So the reason why we highlight this is because, and we're going to get into it, is because Canada's plan is based off of the rejected draft FSA. And this is in Canada's material. They say this themselves. This is not our interpretation. Canada very clearly says that their plan is based on the rejected draft FSA. So if we go to the next slide. So after the rejected draft FSA, most recently in August 2025, so that's kind of where we're at right now, more recently, we had a 2025 CHRT 80. So this is where the tribunal ordered Canada, along with the Caring Society and AFN, to move forward on long-term reform without further delay. So in this order, the tribunal directed the parties to submit a plan for long-term reform, and they said either created separately or together. Caring Society and AFN were encouraged to work with the NCCC and to return with a plan for December 22nd, 2025. And also Canada, again, they could work separately or together. They were, of course, encouraged to work with the NCC. And importantly, this order did not include Jordan's principle. So if we go to the next slide, the real substance of 2025 CHRT 80, which I think is one of the most important pieces, is what we call paragraph 113. And what the tribunal did is they set out a list of their expectations for ending discrimination and also reaching the long-term reform of child and family services. So some of the really key highlights that the tribunal ordered is that, long-term reform has to be for future generations. Short funding agreements or a short agreement is not sufficient. That a long-term reform plan has to improve upon the tribunal's previous orders. It has to include regional and local First Nations perspectives. It has to be evidence-based. Has to align with the spirit of the tribunal's previous findings and rulings. Be culturally appropriate. Respect substantive equality. It has to comply with domestic and international human rights. This is very important. It should align with UNDRIP and rights of children, and to strive for excellence rather than perfection. So these are the expectations and parameters that the tribunal provided for their vision and their expectations for long-term reform. And this is really our guiding light and beacon when it comes to thinking about long-term reform. So if we go to the next slide, so now that you guys know kind of how we got here and how all these things have built upon each other, then came December 22nd when the plans were submitted. So unfortunately, Canada refused to collaborate. And so two distinct plans were submitted to the tribunal to fulfill these orders, requiring a plan for December 22nd. So we're going to be comparing these two plans, and it's been part of this series. And then so we'll start with, of course, Loving Justice. And Loving Justice is the First Nations-led national plan. I should note this is, of course, outside of Ontario. And the emphasis is that it upholds the rights of First Nations children, youth, and families. So loving justice is durable, it utilizes needs-based funding, and it has protections of statutory or special purpose allotment for funding. And we'll talk more about that. It also includes multi-layered accountability mechanisms. And again, the core approach is rights-based for children and youth and leadership as well. And emphasis as well on regional variations, as well as needs-based, flexible funding with capacity funding and funding at actuals as a backstop. And we'll dive more into that as we go. So that's the Living Justice Plan. And then if we go to the next slide is Canada's plan. So Canada's plan was designed and developed by Canada. And again, it is based on the rejected final settlement agreement. And it has preset national envelopes and formula-based allocations. And so what Canada proposes is regional agreements within a national framework. And what they are proposing is to negotiate one agreement per province by September 30th. And if an agreement is not reached, then Canada is going to move forward regardless and use a national framework as the default. And again, the national framework is the rejected draft FSA. So what's important to know here is that although Canada proposes regional negotiations, the funding elements and funding amounts are not subject to these negotiations. And really, negotiations focus on implementation, but there will still be national program terms and conditions. So that's really all that we know at the moment about Canada's proposed approach to negotiations. We haven't seen anything public. There hasn't been any discussion yet about what those negotiations entail or what the process is. So if we go to the next slide, again, we wanted to highlight how the rejected FSA is replicated in Canada's national plan. So again, there's really no decision making for First Nation leaders on funding levels or the architecture, again, beyond implementation. Canada continues to retain control through a national framework. And it is also formula driven with non-negotiable funding formulas. And we're going to dig more into that. So if we go to the next slide on the timeline. So the timeline for Canada's plan is they've indicated that Canada will begin negotiations in January 2026. And Canada's chosen not to wait to hear from the tribunal about this approach. They've indicated that they're just going to move forward with negotiations. And as you guys will see on this timeline, if agreements are not reached by September 30th, then Canada will move forward regardless and file agreements with the tribunal for October 5th. So that's just the timeline for you guys to be aware of. And then the next slide. So just before I turn it over to Richard to dig a little bit deeper in some of the funding comparisons, I wanted to share with you guys a bit of a high-level comparison of the funding basis and approach. And we'll share this information sheet with you guys. But some of the really important things to be aware of is that Loving Justice has funding protection through special purpose allotment or statutory funding, whereas Canada's plan does not have the same protection. And why this is so important is because Canada's plan also has in it that they want all tribunal orders to be replaced. And they want all tribunal orders to be replaced with their plan once it's been negotiated and developed. And why this is important is because previous tribunal orders include a lot of different things, including protection against reallocation. So what that means is, they've made orders on not allowing the use of child and family services funding to cover shortfalls in other programs and services. So by erasing tribunal orders, some of those protections could be in jeopardy. And then as well, Loving Justice proposes to continue funding at actuals until, for certain components, until data and evidence is developed. And this is especially important when we're considering capital funding. Everyone knows how important capital is in child and family services. And when we look at Canada's plan, they outline a capital approach that is proposal-based, where ISC will rank and assess proposals, and it's within a fixed funding envelope. And then so we're going to dig deeper into some of these funding approaches and how they've come to be, but wanted to give you guys a high-level comparative of what it looks like on the face. So I will now turn it over back to Chief Bowden, and thank you everyone for listening to me.
Thank you so much, Stephanie. We know that was a lot of information. We'll now turn to Richard to dig into some of the details. I will let you introduce yourself, Richard, and then the floor is yours.
Thank you, Chief Baudet, and thank you, Judy, for your wonderful prayer, and thank you, Stephanie, for your presentation as well. So, Waligiskeg, Emset Nina Way, Telewizin, Richard Gray, Listigu Jilnu, Emset Nogama. So my name is Richard Gray, I'm Listigu Mi'kmaq, and I'm the Manager of Social Services for the First Nations of Quebec and Labrador Health and Social Services Commission. And I'm also tech support for our Quebec Commissioner to the National Children's Chiefs Commission, Chief Vicky Chief. My section of the presentation today is called Key Considerations and Comparators, and I'll be presenting on the following themes: funding mechanisms, prevention and capacity funding, governance and decision making, transition and implementation, and finally, measuring outcomes. As I present this information, I want you to keep in mind the importance of funding, governance, and accountability, and I will highlight how these considerations will impact First Nations. Next slide. So this next section, funding mechanisms, when we talk about funding mechanisms, I want you to keep in mind this concept of who holds the pen, because it's a critical concept when we are talking about settling the discrimination complaint. Just look now at who decides and has the final say when it comes to these operational bulletins and the terms and conditions of the Child and Family Services Program. It's not the First Nations, and under Canada's plan, they will continue having the final say. Canada will continue retaining authority over levels and timelines and standards under their proposed plan. And there's a strong risk of continued underfunding and administrative delays. Under the Loving Justice Plan, it promotes that First Nations CFS service providers must be provided with a model budget of their funding allocation under the reformed funding approach for their assessment and approval, and they will determine the timing of their transition to the reformed program. In the Loving Justice Plan, by funding at actuals, we will ensure needs are met while creating a cost tracking record to inform future funding approaches while protecting autonomy and supporting long-term planning. So once again, when you think about who holds the pen and the key comparator for both plans, think about the degree of First Nations control the Loving Justice Plan promotes versus the federal gatekeeping approach under Canada's plan. Next slide. Prevention and capacity funding. Here are some highlights on major differences between the Loving Justice Plan and Canada's plan with regards to prevention and capacity funding. First and foremost, We all recognize that prevention funding is a core component of CFS, but it remains inadequate on some fronts. For example, the splitting of prevention funding across First Nations and First Nations CFS agencies can cause potential disruptions in services and uncertainty on who provides secondary and tertiary services. In Canada's plan, capacity issues are further constrained by the lack of operational funding for First Nations delivering prevention services. First Nations are being told top-ups could make up for this lack of operational funds. Canada presumes capacity as a given and doesn't promote it in their plan. I would challenge you to look up the word capacity in Canada's plan to see how many times that word is mentioned. You'll see that it's only mentioned twice. On the contrary, do you know how many times capacity is mentioned in the Loving Justice Plan? 57. So tell me which plan better promotes capacity. The contrast here is that the Loving Justice Plan stresses the importance of prevention funding as foundational and an operational requirement, whereas Canada's approach is discretionary. They tell you that you can transfer funds through flexibility to accommodate for capacity or more prevention, but if services are separated, will this really happen? And they say you can request more funds through the funding adjustment request option, which is discretionary, meaning they decide, not you. Next slide. Governance and decision making. Here I want to stress that when it comes to funding and decision making, the two plans couldn't be farther apart on these issues. The Loving Justice Plan promotes a national framework with oversight by a National Oversight Council made up of First Nations leadership versus Canada's approach, which is regionalized. There's no national voice in Canada's approach. We would be divided and separated. Yet Canada would continue controlling this national program, especially when it comes to the terms and conditions. They promise to listen to regions when it comes to improvements, but there's no obligation to make those necessary changes if they are required. As well, Canada's approach to promoting self-government in their plan is limited to regional negotiations. There's no collective voice. And the worst part is that it's a take it or leave it approach. If you don't like this approach and all the limitations and don't want to negotiate under those conditions, guess what? Their plan is going to apply to you anyways on April 1st, 2027. There's absolutely zero commitment to co-development in Canada's plan. The Loving Justice Plan, on the contrary, promotes that First Nations decision-making will be embedded at all levels concerning the design, management, and control of the CFS program and the reformed funding approach. The Loving Justice Plan also promotes clear dispute resolution pathways when it comes to funding and decision-making. Finally, and importantly, the funding for supports and services, including the oversight and secretariats under the Loving Justice Plan, would be funded at actuals for a set period until we have a solid, informed, evidence-based approach that supports a flexible funding structure. The comparator here between the two plans shows national coherence in the Loving Justice Plan versus a regionalized, fragmented approach in Canada's plan. Next slide. Measuring outcomes. The Loving Justice Plan emphasizes the importance and significance of community-driven outcomes that are tied to child well-being and community-defined indicators connected to data sovereignty and incorporates First Nations-led evaluations. In contrast, when you look at Canada's plan, it's limited to federal matrix, and there's limited recognition of First Nations-defined success. How can you promote collective work when it comes to child and community well-being success without the support of the national and regional secretariats working together with an accountable First Nations-led National Oversight Council? The Loving Justice Plan is the only plan that promotes this. Canada's plan is limited to regional outlooks with no collective First Nations voice. The comparator here is that the Loving Justice Plan is based on community-driven outcomes that are well supported by First Nations versus a limited regional agreement model with no oversight and follows federal administrative metrics. Next slide. Finally, when you look at both plans and you ask yourself the question, what this means for First Nations, I want you to think about control over funding and that good governance determines long-term success. Prevention and capacity must be operational, not optional. National consistency is essential to ending discrimination. Following regional approaches alone won't solve the problem of discrimination. However, it will surely divide us. As well, tribal oversight remains a critical protection until we can build strong, informed, evidence-based data and approaches that allow us to, lastly, measuring outcomes that reflect First Nations priorities. For me, when you look at the question of which plan best meets our needs, offers protections and support, provides the best funding options moving forward for First Nations, it's without a doubt the Loving Justice Plan. That's it for me. Walalio, Namultas, Mset Nogama, my brothers and sisters. Chief Bowden, back to you.
Thank you. Walalio, Richard, it's really helpful to hear those key messages about what this all means to us as chiefs, as rights holders, and as parents and grandparents. We will now go to Dr. Cindy, who really needs no introduction. Dr. Cindy, you've been so generous in always making time to come and speak with us and share information. But I will ask you to introduce yourself before you start.
Thank you, Chief, and my respects to Judy for the opening prayer. And I just want to say to everyone that spirituality has been such an important part of Loving Justice, and it wraps around the guidance of First Nations leadership and all the incredible experts, people like Richard and Stephanie, who you've just heard from. I'm just going to do some high-level things because when we leadership are presented with these various documents, it's a lot to go through at a community level. I think one of the big things to note is how the discriminator, how the problem rather, is defined in each plan. In Canada's plan, it's more about holding agencies accountable, but really, the agencies were not the ones that were being found to discriminate against First Nations children. It was Canada that was found to be discriminated against First Nations children. Canada holds a legal duty to permanently stop that discrimination. So that's one thing to begin to look for. Richard pointed to the issue of there being no dedicated capacity funding to set First Nations up for success in delivering services for their kids. Well, that's made even more problematic when we look at the data that we do have on First Nations children from the Canadian Incidence Study or the Ontario Incidence Study. Both are showing that sadly the compound trauma is piling up on our families and on our children, and it's resulting in much more complex needs than we were dealing with even 5-6 years ago. So the costs of actually meeting those needs are going to increase, and we need to that's why having actuals as a backstop that we have in Loving Justice versus a fixed amount as proposed by Canada is so important. We need to think about what is the most important thing to think about funding. Some of us just instinctually think, well, it must be what the number is. But actually, we've been taught by people over the decades that the most important is having alignment between the purpose, in this case, permanently ending Canada's discrimination, how the funding is structured, i.e., can you use it for the actual needs of children in your community? Or is it governed by bureaucratic types of things such as terms and conditions? And for those of you who are unfamiliar with terms and conditions, what they are is they're a key document that you should be looking for in any funding approach because they govern who's eligible to get the money, what kind of reviews Canada's going to put you through before you are even getting at any of the funding, how do you keep that funding, what you can spend the funding on. And if we look at the final settlement agreement or even the Ontario agreement, Canada has a lot of control over those terms and conditions and can change them with very little oversight or condition. So this is really important, is to look at those documents and look at the structure, the purpose, the terms and conditions, and then take that into your contribution agreements and how it's being implemented. So all that train leads to what is happening for kids on the ground. Separate capacity building, that is really key to ensure that First Nations are set up for success. But here's another thing. If you are a First Nation under that failed final settlement agreement, and you have a lot of capacity, you can use the 2,500 as Chief Bowden identified for the full benefit of your kids. But if you're in one of the communities who's not had that opportunity and has very little or maybe even are just starting out capacity, you're expected to draw from that service money for your kids to build your capacity, meaning your kids get less. So what does that mean at the end of the day? We'll have haves and have-nots even in our First Nations, and that's not fair. We want to set everyone's child up for success. Governance, Richard did a really good job of linking those two things together. Who is making the decisions about the money? And how do those decisions get held accountable? You're going to be looking for, in this case, because Canada is the discriminator, how is Canada held accountable for concerns that may arise regarding discrimination recurring, persisting, or deepening? And what we saw in the final settlement agreement is a very light on Canada's accountability. Next slide. So here's just a little bit of a diagram. I'm not going to go through it a lot in detail. Richard did such an excellent job of showing these pieces. But you can see under Canada's plan the level of decision-making that Canada has over those key components. They defined the national approach with no input that we know of from First Nations. They constrain about what you're actually going to negotiate on in a regional deal, which is basically implementing Canada's plan. You're not making any big decisions. In fact, there are 0 big decisions on the architecture of the funding made by any First Nation in Canada's plan, I would argue. The terms and the timing of the funding and the eligibility is also under Canada's purview and reporting and compliance. Under Loving Justice, it's much more First Nation centered. We're absolutely, there are some places where Canada has decision-making power. That is just a factor that we have to live with. But where they are making decisions, those decisions have to align with their legal obligations to not discriminate against our kids. And those decisions are limited and went under the Loving Justice plan in a way that we don't see under Canada's plan. Next slide. So this is just kind of going through it one at a bit. When you look at the governance dimension and you compare these two, it's just another way of presenting the data. And, you know, I think at the end of the day, what we have is Canada really holding all the decision making. And why is that problematic, you might wonder? Well, that was actually one of the key things the tribunal found to be a part of the discrimination that has happened before, because I'm old enough that when back in 2000, we're working with incredible people like Raymond Shingoose and Judy Levi, Elsie Flett, and many more, sitting around the National Policy Review table with Canada. And Canada agreed that it was underfunding child welfare. It had recommendations to fix it, and it chose not to do it. This is a pattern that we're seeing across the decades. So we need to break that pattern so that Canada doesn't just get to kind of continue harming children with very little accountability. Next slide. So what are kind of lessons learned, I would say, when you get one of these agreements, look at the fine print. You'll get a big headline of an amount of money, but the fine print really matters. And ensure that Canada's conduct matches what it's actually saying. We have been hearing federal officials and political leaders saying that their plan is a step towards self-government. Well, how can it be a step towards self-government when there's zero decision-making on a key architecture of their funding approach by First Nations and zero that we know of First Nations input into Canada's plan? That doesn't make any sense. So we need to line those things up. The most concerning provisions regarding Canada's conduct, accountability, limitations on, the money, whether or not they have to pay it or not, those provisions are often found in the very back end of the agreement. So you're going to see, as we did in the final settlement agreement, tens and tens of pages where there was like the money, you're going to get this amount of money and this amount of money and this amount of money. And it wasn't until you got to the end of the thing where you started to see, well, actually, Canada doesn't have to pay that money. And if they don't pay that money, there's very little accountability. And by the way, they're controlling a lot of that, how you spend the money. So look at those back pieces of it. Don't just get kind of fixated on the front end of the agreement, where usually a lot of the quote good news is. The fine print is closer to the back. And look at the appendices. That's where the terms and conditions often are. Take a good look at those terms and conditions. Be aware of time-limited agreements. Remember, Canada's under a legal order to permanently stop its discrimination, not just for 5 years, not for 7 years. This has got to be a forever stop. And we have to hold that obligation as First Nations because the survivors from residential schools and the 60s group both have called upon us to make sure this harm stops for children. So it's not only just a legal duty for us, it's a sacred duty. And I think it's one we have to uphold. It's the least we can do to pay honor to the residential school survivors, the 60s group survivors, and all the children and young people who have been harmed by Canada's discrimination in this case. Next slide. So summing up, look at the funding purpose, the structure, the terms and conditions, the agreements, accountability, enforcement. Those are key. Make sure that the outcomes of kids, that we focus on the outcome, which is this money is supposed to permanently stop discrimination for children and youth and families. That is where the discrimination was found. That's the type of change we need to see. And make sure there's a separate capacity building stream. So we're setting First Nations and their children up for success in receiving those high need services that they need. And second of all, we're not creating have and have nots in our own community. So I think that's it for me. I just want to say what an honor it's been being a part of this webinar. And then back to you, Chief Bowden. Thank you.
Thank you so much, Dr. Cindy. The funding has always been the most obvious problem, but you have given us a good idea of what else we need to look at to understand how these plans would land and unfold over time. We will take some questions now, but first I will remind everyone that our next webinar will be on service level agreements, and that will be 2 weeks from now on March 27th. You can also head over to the Our Children Our Way YouTube channel, where you will find recordings of all of our previous webinars. I truly recommend that you do because the Loving Justice Plan, as well as Canada's plan, is laid out and explained in a way that all of us not only can understand, but that we can share with all of our colleagues and families in our nations. So right now we will read some questions. Okay, the first question we have is, do you have info on, oh, sorry, it's going up here on our questions. Do you have info on funding streams for CFS agencies and difference between kinship homes and foster homes? And I will ask Stephanie if she could answer this question.
Thanks, Chief Bowden, and thanks for the question. Cindy, I'm wondering if you could help me out with this question.
Yeah, I'd want to know more about the details, but in general, the federal government is not in the business of defining placements for children. That's one of those decisions that should be left in the hands of First Nations and their experts at the local level as to what type of placement actually meets the needs of those children. What we've seen in the past is that the federal government says, well, okay, well, this child is in this placement. Well, that's actually not eligible for reimbursement under maintenance, or it's eligible, but to a lesser level. That type of decision-making has been found to be discriminatory and is, in my view, a direct overreach of the expertise that the department has. Because you folks are on the ground, you know these families, you know the children, you know the caregivers, and you're in the best position to decide where those matches come in.
Thank you, Dr. Cindy and Stephanie. The second question is, how does the NCCC and Canada's submission speak to First Nations who enact their own law? Since CHRT rulings apply to First Nations, Bill C-92 claims to support First Nations, and First Nations Child and Family Services reform applies to First Nations. And Dr. Cindy, either yourself or Richard you're welcome to both answer this question. Please and thank you.
If you don't mind, Cindy, I'll start. It's a good question. I just want to remind people that Chief Baudin is from the Cowessess First Nation, and that was one of the first communities to implement their own law regarding exercising their jurisdiction. And we're graced and blessed to have Chief Baudin, as you heard, as part of the National Children's Chiefs Commission. So our thoughts and considerations regarding First Nations wanting to take a next step in terms of exercising their jurisdiction is always in our minds and at the forefront. We know that communities using this delegation model is a limited autonomy approach, and First Nations who want to move from that have the option now of exercising their jurisdiction under C-92. And one of the things that I think that we want to underline the most in terms of what Loving Justice Plan does is that before First Nations ever move towards exercising their jurisdiction, we want to make sure that all their needs are met regarding funding. And having years of experience in terms of delivering services that are based on fundings that are needs-based rather than formula-based, with the backing of actuals under the Loving Justice Plan, will provide that backstop for First Nations communities to look at what their real expenses are in terms that are based on needs before we move into a flexible funding approach. So once we have that critical, informed, evidence-based information and data, and we analyze it, and we look at how we can improve the funding formula after we have that information towards a flexible funding approach, we'll be in a far better position. First Nations will be in a far better position to move towards the exercising their jurisdiction under C-92. I think that Loving Justice Plan does that. You heard me earlier mention that when it comes to Canada's plan, there's lack of support for capacity. So you can imagine a community that's in the program right now, or a community that's just exercising prevention services and wants to then take that big jump to move towards exercising jurisdiction. That's a big critical question for First Nations communities to answer, whether they should be doing that or advisable that they should be doing that when you look at capacity. Protection services are not easy services to deliver. They're complicated, especially when you're dealing with abuse, sexual abuse, physical abuse. These are very complex situations. So capacity is an important element, and I think the Loving Justice Plan promotes capacity and develops capacity, and I think it's well placed to support First Nations communities who eventually want to move towards exercising their jurisdiction. I'll leave it at that. Dr. Cindy?
Yeah, thanks, Richard. And I echo your recommendation that Chief Baudin be looked at as an expert in this particular area. We really want to set people up for success, regardless of the type of jurisdictional model that they would like to see. What we were finding is that the federal government was using its plan, the final settlement agreement, and then later the Ontario final agreement, as a ceiling for First Nations who are sitting at different negotiation tables. We're clear in Loving Justice that what we're proposing is a minimum human rights-based floor, and that adjustments ought to be made above that. So that's a totally different kind of approach. Canada is not really in its expressions of these different agreements, been holding itself to a serious human rights floor that ensures that discrimination will stop and not recur. We've heard, by the way, from many First Nations who are interested in jurisdiction or at coordination tables that Loving Justice has been a very helpful reference to them. Loving Justice is available, as is this webinar, in French and in English. So if you're at those tables and wondering how to align funding, what kind of definitions might you be looking at for your particular agreement under self-government, Loving Justice may well be a really helpful resource for you in that particular way.
Thank you, both Richard and Dr. Cindy. From our perspective, just to sum up here, from our perspective, we are the first First Nation that enacted our own law. And my first comment to anyone who asks Kausas or myself if they should go down the Bill C-92 path. And I say, that is up to the people, that is up to your people. And my caution is always to ensure that, to know that once you enact your own law, once you create your own law for your First Nation, it's not an aspiration law, or a piece of paper. It's not what you hope to deliver for your children and families. It's not a vision or a mission document about what you would love to see, the North Star of what you would love to deliver for your children and families. This is your law that states what you must deliver in this moment of time. When you enact the law, that means you are completely outside the Indian Act. You are completely in charge and are liable for looking after your children and families. Now, as Richard said, capacity is a huge area within that. If a First Nation needs to have all of those secondary types of services, as well as models in order for C-92 to benefit your children and families in the way that they deserve. What I mean by that is that if you look at all of the different, basically from conception to post-majority, and also I say womb to tomb because many of our grandparents look after their grandchildren. And so there's so many considerations along that line that your law has to speak to, that you are now completely responsible for as a First Nation. Under C-92, it also, if your law states that you look after all of your children, that means both on and off reserve. And with your funding model on C-92, it is for on reserve. So you have now put yourself in a position, or your First Nation has put yourself in a position where you are responsible by your own law, which has been, it's been recognized by the Supreme Court to look after all your children. And when you get complex case scenarios, and let's face it, many of the children and families that we work with, especially in terms of protection or very, very intense prevention, as well as post-majority. It costs hundreds of thousands of dollars to properly look after and to take jurisdiction over your children and families. Speaking to already, whether you live in the city or you're on reserve, the services that are required, the mental health services, the addiction services, policing, judicial services, the health services, the education services, those all have to be in place and work in alignment with your service delivery model, your child welfare service delivery model. And so when you start to break that down and you start to piece whether or not you're looking at an initial agreement or a successor agreement, and CHRT is currently working on our successor agreement, and we are moving into our 5th extension agreement because Canada and CHRT cannot agree on a funding model that works for our children and families. It does not work for building capacity in terms of capital. And we are very much, we're working in partnership right now. I do want to say that. But I don't believe that the government or First Nations really understood the amount of capacity that would be required, the amount in terms of human resources, in terms of capital, in terms of all of the services that are required, as well as as well as how everything, when we talk about alignment, it's about all of the services that you currently provide, as well as your child welfare model. So it is a beautiful thing for us as First Nations to exercise our rights and our jurisdiction because we've never given it up. Pardon me, I'm just feeling a little under the weather today. We have never given up our jurisdiction. We are just asserting our jurisdiction. But we have to ensure that we are not recreating broken systems, nor are we becoming part or becoming broken system. Our children and families deserve so much more. I am honored to represent Saskatchewan and have my colleagues have me sit at the NCCC. And for myself as CHRT and the chief of CHRT, I am constantly looking at exactly what the bar is. And as we all work together to raise that bar and have the floor meet these standards as opposed to the ceiling, we understand that whether it's C92 or long-term reform, oftentimes the government uses that as a baseline. So we're all working together for the betterment of our children and families, whether or not we are at a C92 or we want to be part of long-term reform. So if there's anything that I could say is that definitely look towards having your own laws, but just make sure that you have the services and the ability to care for our children and families in the way that they deserve. Thank you. The next question that we do have is from Lacey Williams, and it is, we have received notices of budget adjustments from ISC named long-term reform, poverty, long-term reform, operations, long-term reform, emergency, etc. They have stated they're honoring CHRT 2022-08. They have also delivered the $75,000 baseline for prevention to communities. What would you recommend regarding the use or not use of these funds to help hold Canada accountable? Dr. Cindy, could you read this question or answer this question?
Thank you, Chief, and thank you for the question. That's a very good question. I typed the response. I am going to post in the host and panelist. I don't have access to the whole chat, the actual order that is being referenced here. And there is no order for Canada to pay a minimum of $75,000. The top-ups are also not mentioned in that particular order. Rather, this appears to be Canada implementing its plan regardless of the views of the First Nations or, frankly, the tribunal. And what I would highly recommend is that where you're receiving contribution agreements that are not aligned with your views of what your children need and are not aligned if you have, looked at loving justice and prefer to take that model, that you write to the minister as well as their officials, Duncan Farthing Nickel, who is their affiant on supporting their plan, as well as Lisa Legault, the director of Child and Family Services, and advise them of your concerns. You can also consider taking legal action if what is happening is a breach of the existing tribunal orders. So for that, we would recommend you reach out to your legal counsel. One of the things I want to make a note of is this whole $75,000. When we saw that for the first time at the Caring Society in Canada's failed final settlement agreement, we had no idea where that amount came from. So Stephanie led a study along with a group called Engage First to look at what is the minimum amount a First Nation of a small size would require to deliver services. And the result of that is 1.2 million, not 75,000. And that makes a lot of sense. So you can find the Engage First report on our website. I would also note that I've not been able to find any convincing evidence from Canada supporting it 75,000 in either the final settlement agreement that was voted down by leadership, the Ontario final agreement that is currently before the tribunal, or in its plan that is put forward on the national plan, which sadly I just saw a media clip of the minister in the House of Commons selling Canada's plan and not even mentioning the First Nations led and developed Loving Justice plan. That really, to me, is a sad commentary on the credibility, frankly, of the government's statements that it wants to listen to rights holders, because rights holders got together and created what I think is a very, very good plan, and it's not even being paid any attention to by Canada. So Richard, Stephanie, I don't know if you have anything else to add.
Dr. Blackstock Heights, Richard, no, I have nothing further to add. Great answer.
Thank you. The next question is, would Loving Justice's formula for funding look at citizenship as opposed to reserve residency? And Richard, would you like to answer that?
Sure, I'll have a crack at that. I think this whole subject of residency as on reserve and off reserve is an interesting question. For purposes of the discrimination complaint, I think the CHRT is within Child and Family Services program is limiting reform to on community only. But I absolutely agree that I don't think we have any choice but to look at how our supporting our members off community, and it's through no fault of their own. There are many structural determinants that cause them to go off community, lack of housing, etc. I think that's the most important one. And most, as you know, communities know, most members who live off community and in close proximity come back to the community to get their services. There is that attachment. There is this issue, though, of limited funds within the Child and Family Services program. And then under the terms and conditions, they have this language of ordinarily on community or on reserve. And if you ever do maximize, all your expenses in your CFS programming, and it's come to ISC realization that you're offering a lot of services to your members off community, you could be put into this justification situation. And I know we haven't heard much about these independent audit evaluations that ISC was conducting a lot prior to the complaint being filed. But they always have that option of doing these audit evaluation on your services, um, which could which could ultimately result in the community being notified that they have to pay back certain funds. I think most people who have worked in the CFS program and are responsible for managing it know what I'm talking about. Um, but I would challenge the federal government too on this whole concept of C92. C92, it has minimum standards that say apply to all our members, irregardless of residence. And if you look at Section 12 of C92, it says that First Nations communities have a right to intervene in tribunals to make representations on behalf of community interests for their members, on and off community. And if under C92, provincial service providers have a responsibility to inform First Nations communities now that they're taking significant measures and they're intervening in the life of our members. So it's possible that either our members off community or the provincial government service providers will inform the community that they're doing this. So if First Nations communities are exercising their CFS program, and through this program called First Nations Representative Services, are being told, well, this is only for ordinarily on reserve. What do you do with this limitation that's identified in the terms and conditions? And knowing that C92, Section 12 and 13 says that you can intervene in cases where your members are being, where protection services are intervening with your members off community. What do you do? Do you say, well, no, I can't offer you services because ISC won't fund me? That's a horrible situation that First Nations communities, I think, are being put in, especially when it comes to exercising the minimum standards under C92 and protecting our members. So um, we're limited in our arguments with the tribunal in that regard, but I don't think politically there's limitations on having those discussions with Canada moving forward. And it may come to another challenge to the federal government through other judicial processes to address that question. So I'll leave it at that. I don't know if Dr. Blackstock wants to add any more information.
Just one note that just a reminder to everyone that Jordan's principal element of the case does recognize all children recognized by their nations as eligible for Jordan's principle. That would include social services. So that is something that it'll be coming up later, is long-term reform on Jordan's principle, and something for you to keep in mind as a way of meeting those families' needs.
Thank you, Dr. Cindy and Richard. I have another question for both of you. Could you describe the ongoing amendments process for Loving Justice?
Richard, do you want to start?
I'll let you go first, Cindy. I started first on the other one.
Okay. So everyone, one of the things that we really wanted to do is respect what we've learned out of the final settlement agreement process for leadership. And that is that Loving Justice is First Nations designed. It's based off of the feedback and the direction of First Nations. So it really is a First Nations developed plan to put before the tribunal, for the tribunal to make a decision about what eventually is going to happen with First Nations child and family. But leadership didn't see what we rolled up and what actually became Loving Justice until December 22nd. So we wanted to provide a further opportunity for leadership and their experts to offer improvements to the plan. Are there things that are needed to really stop Canada's discrimination and make sure it needs to happen again? Or any alternative, maybe you don't have an amendment to offer, but maybe what you're looking at is, for example, on the Child Impact Review Committee, which is to review all of the department's policies and bulletins before they hit the ground to see what's going to happen for kids. Maybe your nation feels it's particularly important to have a youth representative, maybe more than one on that committee. You can also do that. There are links to both amendments, and we would request that where you make an amendment, that you note where we've talked about it in the plan, and then offer us improved wording. And that amendments that are national in scope, that align with the tribunal's jurisdiction, and the direction already given by leadership are going to be the ones that we're going to be most able to act on. So just to let you know that our object is, it's up now on the National Children's Chiefs Commission website in both French and English. So you have had the Loving Justice Plan for now nearly 3 months. So if there's things you think are missing, get on there and let us know about it. And then we will be rolling up those revisions in another version of the plan that will be available, we're hoping, in the middle of April. And the reason we're targeting that date is that leadership said that if there was a negotiated agreement, they wanted 90 days to look at it before making a decision at the AFN meeting. Well, this isn't a negotiated agreement. This is a litigation process, but we still wanted to honor the spirit of what chiefs have said to us. So there will be a further opportunity, albeit limited, because of the tribunal schedule in July, in the wake of the Chiefs Assembly meeting. There will likely be a motion asking leadership to support Loving Justice as the position going forward on the tribunal outside of Ontario. So you can find all that information. I see Kayla has already posted it on the website. Richard, is there anything I've missed?
The only thing, thank you, Dr. Blackstock. The only thing I would add is that it's not only limited to text amendments to the Loving Justice Plan, but also how can we improve implementation? That would be the only other thing I would add. Thank you.
Okay, the next question is, how do communities get involved and support Loving Justice? And anyone who would like to answer this question, please feel free.
Well, one of the key ways is to let your voices be known. Work with your First Nations leadership and write letters to the minister to make sure that she's aware, the Prime Minister. If you're a leader yourself and have access to those people, please let them know how you feel. And also copy us at the Caring Society, at the National Children's Chiefs Commission. Every region outside of Ontario has a commissioner for the National Children's Chiefs Commission. You can find the list of those persons on the website. Make sure they're kept informed. Pass resolutions. Either it could be a band council resolution or whatever decision-making tool you take as a nation, if you have a traditional government, for example. And as a sub-regional or regional organization saying, hey, we've taken a look at both of these things, and this is really what we think is, in the end of the day, the best position to put forward to the tribunal for our kids. I'd also make a plug for something really important coming up. Stephanie reminded it with me with Spirit Bear in the back. On May 10th, please mark your calendars, because that's a day we call Bear Witness Day, to honor the spirit and the legacy of Jordan River Anderson, Jordan's principal. So please get your teddy bears. That is the symbol of Jordan's principal. Organize children in your community to have tea parties. Write to elected officials. Encourage leadership to really call on Canada that day to fully implement Jordan's principle and stop Canada's discriminatory conduct. And you can find all kinds of free resources on the Caring Society website. And a big thing that happened this year is the Senate of Canada has officially adopted May 10th as the Bear Witness Day forever and ever going forward. And that echoes earlier resolution already passed by the Manitoba Legislative Assembly. So you can encourage your provinces to get on board with the growing trend of making Bear Witness Day a day to honor Jordan River Anderson, an official day in your jurisdiction, either on the provincial or federal side, but also, of course, in your nation itself. It'd be wonderful to see nations adopt that as an official day in their nation.
Thank you, Dr. Blackstock. Then the question is, are there any plans by the AFN or NCCC to convene a national conference to share and focus on Bill C-92 experiences, pre, during, and those enacted? And I guess I could answer this question in saying that, to my knowledge, I can't speak for the AFN. For the NCCC, we have a very specific mandate that has been given to us by the Chiefs in Assembly, and that is to focus on long-term reform and look at and submit, a First Nations response to ending that discrimination. Now, saying that, like I had talked about before, there's so many similarities in regards to whatever stream that we as First Nations decide to take care of our children and assert our jurisdiction over our children and families. And I'm more than willing and pleased to bring this back to my fellow commissioners to see if there's any opportunity for us to have more of a global type of response so that people could understand, not only through these webinars, but the different types of jurisdiction that we can assert, whether it be Bill C-32, C-92, pardon me. And like I said, I'm not feeling well today. And long-term reform as opposed to provincial jurisdiction, federal jurisdiction. And I will take this back to our commissioners. Thank you for that question.
Chief Baudin, it's Richard. I can add some additional information as well. I'm not sure if how much members know, but the 5-year review of C-92 is coming up as well, and I know that regions have now been notified that ISC has some funds available for regions to start doing consultation on C-92, the review of C-92. So that's happening now. We were announced that there were some federal dollars from ISC for this end of fiscal year, but we were also told that there were those same dollars would be made available in fiscal year 26-27 to conduct this review. And I guess the goal of it is to have each region propose amendments or improvements to C-92. So that process is supposed to be happening. And I would also presume that because of the importance of this matter, probably and more than likely, we would look at a national event where I think First Nations would come together to talk about those changes and ask leadership to promote those changes moving forward. So I know there are things that have to be discussed with the AFN moving forward, but I also know that there are going to be discussions happening in regions. And I'll leave it at that, Chief Baudin.
Maybe I
Thank you
could
very
just
much.
quickly chip in, Chief, if it's okay, and remind everyone of the amazing conferences offered by Our Children Our Way, including the annual Loving Justice Conference. It was held in Saskatchewan last year. It was a great success, and it focuses on jurisdiction. So even if NCCC and AFN are not organizing something, there's a forum. It's really well attended, often even includes international guests. And I would highly recommend to everyone on this call to attend the Our Children Our Way conference, but also Loving Justice, which is specifically on jurisdiction.
Thank you, Dr. Cindy. At this time, it looks like we don't have any more questions. And so I would definitely like to once again thank all the panelists for joining us today. And we do this out of love for our children and our families, and as well as for our nations, because we know how much our children matter to us. It's not just a word to say that the children are our future. The future is today, and we are all working very, very hard to ensure that our children get the best that they deserve. And so for Richard, Dr. Cindy, Kayla, Stephanie, thank you for all the time. Michelle, I want to give you a shout out because you work so hard. Vincent, for all of your hard work and the technical work that goes behind this. We as commissioners, we are the voices. However, that our technical people in each of our regions, they are the heroes. They or the sheroes or the theyros. They are the ones that uplift us in answering, in listening, and our elders. We talked about the very important part of ceremony and prayer, and we as commissioners, as technicians, we're very committed to that spiritual part of this work that we're doing on behalf of our ancestors and on behalf of those yet to come. So, for myself as a commissioner, I have to say that this has been an incredible experience for all of us as we work together with our common goal. And at this time, I would like to ask Judy for a close or a thank you prayer. And also, I just want to say that there was a final question here, and I'm having trouble getting it. It's just basically we want to announce that Our Children Our Way National Conference is from November 30th to December 3rd in Vancouver. And that I think was the final question. So everyone, thank you for spending some time with us on behalf of the children, on behalf of our elders who have given us this, and our knowledge keepers, our Kateyak, who have placed this responsibility on all of our shoulders in the honoring of our ancestors and the honoring of those yet to come. I hand it over to Judy to give our prayer and see you all down the road. So thank you very much.
Cooksham, thank you. Chief Bowden and Dr. Cindy Blackstock and Richard Gray. Thank you for our panel today. I'll offer a closing prayer. Cooksham, Kilcook Creator, we thank you today for bringing us all together from across our different regions and nations across Turtle Island to be able to share for our heart-centered work, our children in the center, as we keep mindful of our children in our thoughts and our prayers and our actions, and that our actions will speak loud and clear in regard to any of the decisions we make and to keep them safe and end the discrimination and racism they face on a daily basis. And we thank you for all the ones that are gathered in the circle, for the ones with the great questions and the forward thinking and the work they do with their children and families and their respective nations, and how they are working very hard to do that work. We also pray that we can come together again to continue the dialogue, to continue the sharing, and continue the discussions in regard to this pivotal time we find ourselves in, Creator, for the opportunity to make systemic changes, but also to bring in the full potential of our children, the full potential that they ought to have without any barriers, without any discrimination that they find themselves in. And also that our children, who are our future, but also are here now. And we're also speaking about the ones that are coming, Creator, and their lives that will make big differences to us as our children are already. So we thank you, Creator, for Mother Earth and the water and all creation. And we also thank you, Creator, for our ancestors and our guardians and all those that walked before us, and the knowledge holders that still do the prayers and the ceremonies and carrying the sacred bundles for us as well. They pray many times on a daily basis and through the seasonal, like the March 21st that's coming up, all the spring ceremonies that are coming, all the prayers that they will be giving the children. And the families and all the loved ones and friends near and far in our community. So we thank you for those that keep the good work going for all of us. We thank you again, Creator, for all the ones that are on the panelists today, that they are dedicating and sacrificing their time and energy for this work. It's very hard work, Creator, so please uplift them and keep them safe, as well as all of the ones that took time to join the call to dedicate their energy and time to this. So we thank you, Creator. Please be with us today and on the weekend as we rest and rejuvenate ourselves to continue this work, always for the children. So we thank you, Creator. And please help love support resources to anyone that lost their families or struggling with families right now in any way. And also the ones that need the support, mental health, addictions, and elderly. And anyone that just finds themselves feeling lonely, feeling where they need more love in their life, that will come to them in a good way, Creator. Cooks Jam, Cooks Jam, Cooks Jam, Cooks Jam. Thank you, everyone.